Well, now let's get into this story, particularly for those who are looking for jobs and have criminal records. The Labour Court in Gqeberha has ruled that a data analyzing company, LexisNexis, should employ a man who had signed a contract after they dismissed him when they learned that he had a criminal record dating back to 2001. Ellsworth O'Connor was denied the job by LexisNexis when the organization discovered past offenses of theft and fraud, despite the potential employer having earlier extended him a job offer by email. Well, the Labour Court supported O'Connor's claim and ordered LexisNexis to honor its job offer, as the conviction was ruled an arbitrary ground of discrimination. But let's unpack what this means and the precedent that this possibly sets. And for that, we're joined by John Botha, who is the CEO of Global Business Solutions. John, a good morning to you. Thank you so much for joining us. I mean, your first thoughts are seeing this case and what this possibly could mean for job seekers with criminal records, in your view.
Yeah, for me, what it means really is that the law under the Employment Equity Act is very, very focused on fair discrimination. And one of the key grounds on which you need to discriminate fairly, Naledi, is what they call inherent job requirements. So whether it's race, gender, sexual orientation, or in this case, a criminal record, the employer or the future employer has to ensure that whatever criteria they're going to use to exclude someone is in fact proportional and rational in relation to the job. And, you know, as you said, this is a senior data discovery and enrichment position. It's a data analytics position. And the fact is the criminal record was, 23 years old. It had been expunged. And the court really said, listen, we need to look at reintegrating people into society, firstly, and secondly, there's no proportionality or direct link. So that was the big issue here. And
so what do you expect this is going to mean in the future? I mean, it'll be interesting as well to sort of look at what the Employment Equity Act says, and we'll unpack that in a moment, John. But what this will mean moving forward, for someone who's watching this conversation, has a criminal record, let's start with the basics, right, just to clarify for them. I apply for a job, perhaps in data analytics, and I have, a conviction of, a past conviction of fraud, for instance, right? Let's clarify this. Is the onus on me to disclose that, firstly?
Well, it would be good practice to disclose it, as Ellsworth did in this case, because, if you don't disclose things up front and they become an issue later on, there could be allegations of dishonesty against the job applicant. So I think the job applicant has to be forthcoming in respect of this. Yeah. Relying hopefully on the integrity of the employer to make a decision in respect of fair discrimination, and not to use that against the person, but to build trust and say, well, this applicant's been vulnerable. This applicant has shown transparency, and therefore looking at the job and looking at the person who's best for the job, we'll employ them. So I would say job applicants should still be open to disclosure. But the onus is ultimately on the employer to prove the discrimination is fair.
Yeah, and this is where I suppose we could sit a little bit on the limitations then for the employers, right? I'm looking at the Employer Equity Act. I think it's section 7.3.32, and I'm going to read it out. It says, an employer should only conduct integrity checks such as verifying the qualifications, conducting credit references, and investigating whether the applicant has a criminal record if this is relevant to the requirements of the job. Now, what happens in the case where perhaps, again, we're a business that does data analytics, but we're interviewing somebody who has a conviction perhaps for rape or carjacking?
Yeah, that's a very good point that you raise. And, to draw an analogy, if I was to be appointed the CEO of the Arrive Alive campaign, that would be a big problem if I had a previous record in respect of maybe driving under the influence. Because there's a direct, proportional and rational link between my criminal record and the very essence of the job that you're considering me for. But if there isn't that link, what the court is saying, you cannot use that as an arbitrary ground against that person. And I think the merits of the case are very important. You use rape as an example. I think that rape is an example that would potentially be quite impactful in an employment environment where, people are busy connecting. You want to build a relationship and a space at work which is safe. So rape in relation to that could be potentially a bigger issue. And also looking at how long ago that happened, every one of us, I believe, Naledi, have in the past committed some form of conduct that was not acceptable. Whether it was at university, whether it was driving after a few drinks. I believe that if people have demonstrated remorse and they have, let's call it, revisited their behavior and they've mastered their behavior, and if it's not a direct impact on the job, the reintegration into society for me would trump any stereotype that you would deny the person entrance into the workplace for. So, I think it's a combination of law at its best, but also fair discrimination. Whether you've got a criminal record or whether you're excluding someone because of their sexual orientation, they're both equally important in undoing the injustices of the past.
Yeah, it's a tough one. And just sitting with that example that we made, it's cost us quite a bit where perhaps an employee has been granted that reprieve, given a job, and we've seen things go terribly wrong. I take you back to 2019, and you remember this name, a lot of us do. The young student from UCT, Uyinene Mkhotyana, who was raped and murdered by an employee of the post office. Now, if we go back to that particular case, the employers allegedly, and according to reports, knew that he had a criminal record from a 1998 conviction for car hijacking, and gave him, and he maintained his job and committed this massive, horrific crime, right? So there are, obviously complications when things do go wrong. And that's where I suppose where you'd get employers getting particularly nervous. Do employers have the resources, though, to do the adequate research and checks that they need to be doing when they employ someone?
Absolutely. They are absolutely free to do credit, criminal reference checks. You indicated the laws, provisions in that regard. There's nothing preventing you from conducting those checks as long as you use the information appropriately in relation to the job. So, they're credit bureaus, they do qualification checks, credit checks, criminal checks. There's a lot of information that can be accessed by the employer. And once again, the challenge is what the employer does with that information. And it's about the correlation between that result and the actual job itself. And I think in this case, in the Ellsworth case, what happened here to aggravate matters, this candidate was then offered the job, even though he voluntarily disclosed this particular criminal record, and then LexisNexis reneged on that subsequent to that. So now you've got two issues. You've got the one challenge of, is it fair to exclude Ellsworth from employment? And the second one is, well, if you've made an offer and it's been accepted, then there's a contract in existence. Yeah. So you can't just say, well, I'm retracting the offer. So, there was a very, very loaded merits to this case. Yeah,
I'm running out of time and I need to wrap it up, but I want to squeeze this one in. Just looking at this story and from a broader point of view, right, what we're doing in trying to rehabilitate people, reintegrate them into society, the confidence level that you have in our, I suppose, systems in place to rehabilitate people that have been convicted of crimes, have served their time. Are we doing enough to integrate them sufficiently into society so that they don't re-offend? Are you confident in that?
No, I'm not confident in that. I think, as with any other unjustifiable grounds, I think the very sight of a criminal record, even a credit check, is often unduly used to exclude people. And without engaging with them, without looking at opportunities to accommodate them and to try and mitigate risk, like the post office thing you spoke about, sometimes on a balance of probabilities, you can't go there. But in many instances, I think employers don't bother to go deep enough into the nature and extent of that individual and the merits of that person and their behavioral change and remorse that they've shown. So it's unfortunate, but it is a balance, and it's
Right.
a difficult one.
Yeah, a very, very difficult one, but thank you so much for speaking to us. We really do appreciate it. John Botha is the joint CEO of Global Business Solutions on that discussion. And share your thoughts with us at Newzroom 405 is the handle.